May it please the Court again, Ron DeRosa on behalf of the Commonwealth, and excuse me, I forgot to introduce who's sitting with me as Assistant District Attorney Ellen Graydon from my office.
Mr. DeRosa, could I ask you a question to start with?
Please go ahead.
As I read the papers that have been filed, it has come to light, I think, that either Judge Lowy or I think it was Judge Lowy sent this to Judge Kratsley, the motion to reconsider. Is that correct?
I don't know if I would characterize it as Senate, Your Honor. The way I understood the transcript was there was sort of a conversation which didn't come until after the fact, until actually I think the Commonwealth had filed its brief in this matter.
Yeah, I'm not saying that you knew that before.
That Special Magistrate Kratsley had, I think during a status hearing in the Milette case, had said, you know, something to the effect of, I had asked Judge Lowy about it, and Judge Lowy said, yes, it was okay to go ahead and reconsider it.
So if those are the facts, I guess doesn't this then become exactly the same question as the first case that you just argued?
I would suggest that it's still, I guess, if he had given him the authority, then it would be the Superior Court delegating the reason. And yes, perhaps it would be the same exact case. But so of course, as I've stated in my brief, all my arguments about stays of executions with regard to the Charles case apply in this case.
Right.
Our case we had brought here because, in our view, Special Magistrate Kratsley had stepped beyond the bounds of his mandate when he had ruled on a motion that had been ruled by a judge whose authority was superior to his. So, I mean, I think my point would still be that Judge Lowy didn't have the authority to give him that authority in the first place.
It's the same argument as before,
yes.
Right? Yeah.
And just following up on a couple points I just argued, in regards to the November 9th order that the defendant has argued the Superior Court relied on, I would point out Judge Lowy did not, in fact, rely on that order when the argument was first made to him that the court didn't have the authority. Number one, because it wasn't in place yet. He had relied, based on the affidavit of Assistant District Attorney Shea, on Commonwealth versus McLaughlin under the inherent authority. So I would suggest that even Judge Lowy, and then later on even Judge Liu, didn't point to the November 9th order. So I would suggest that would suggest that the November 9th order of this court wasn't controlling with regards to motions to stay execution of sentences. I would also like to just follow up on the court's questions about motions for new trial. Motions for new trial are going forward and being allowed based on what discovery has been provided to this point.
Perhaps there's more discovery available in some cases than in others. I mean, are drug files being made available in some cases?
Not based on the two rulings I've read. The drug file hasn't been available. I believe we've pointed that out to the court, that that's a critical piece of evidence for the court to analyze in its ruling on the motion for new trial. It hasn't been persuasive to this point. I suspect those arguments would be made later on appeal. But the motions for new trial are going forward given the discovery that there has been. So some defendants are, in fact, in their strategic decision under Rule 30 as it exists, believing they have enough to go forward on to undo the conviction.
The problem, of course, is that the evidence that they need is in the possession of the Commonwealth. That isn't often the case when you're filing a motion for a new trial. The evidence you need to meet your burden is in the possession of the Commonwealth, but it can't be turned over.
Not in your possession, but in the Commonwealth largely.
Possession of the Inspector General, who's still doing. But some of the defendants are simply just. They may not think they have. I mean, I don't know what strategic reasons they're thinking about. But I mean, when we're talking about these cases, the nuances are whether she was the primary, and then what's the allegation, whether she dry labbed, and of course all of this wasn't presented or it was simply, put forth before the special magistrate or the judge. Annie Dukin was the primary chemist on my case. So I have a reasonable likelihood of success on my motion for new trial, which, by the way, is sort of a standard because we're outside the rules. We've just, at sort of the Commonwealth suggestion in these cases, I would suggest, we've applied, even though, because there is no rule in place. So, when these hearings went forward, we said, the court doesn't have authority. Were the court to find it has the inherent authority, it should apply a standard akin to the motion to stay in the context of appeals. And again, it's all sort of this ambiguous.
I thought they were. I mean, I thought.
No, those, I'm not suggesting.
Standards are being applied.
That standard is being applied, but it's, in essence, a made-up one because this.
Well, you don't have a record, for one thing, in quite the same way available to you, do you?
I'm sorry?
You don't have the same kind of underlying record that you would ordinarily have in the context of a pending appeal.
You would if there would be the hearing on the plea, I guess, and there would also be.
Yes,
were
but
there
at
an
the time of the
evidentiary
trial, you wouldn't have known about the
Were there an
the
evidentiary hearing on the
lab
motion?
issues.
Were there an evidentiary hearing on the motion for new trial? You would have a record to base that off, and a ruling applying the law with regard to whatever the claim is, newly discovered evidence, whatever the claim happens to be.
But you wouldn't be able to do a full-scale hearing on the Hinton Lab issues as they affect your client, would you?
Given the defendant is always able to meet his burden to summons chemists to.
So you're saying full-scale evidentiary hearings about the Hinton Lab could be done in motions for new trial?
I don't see why not. I mean, that would be.
Now? You're not going to be able to get any of the information.
From the chemists themselves as to what the process was, Your Honor?
No, what happened in my case?
Well, that's true. I guess without access to the lab files, the chemist wouldn't be able to review it and say, for sure, I did these tests.
Or what happened in the lab. I mean, more generally, you're not going to be able to get that either.
Well, I bet they could always, in the new trial motions that have gone forward, we have actually stipulated to avoid this burden to police reports, the police reports of the state police that began the investigation into Ms. Dukin in the first place, to the grand jury minutes. So, a record was developed in regards to the motion for new trial that there was actually some evidence before the court as to what the wrongdoing was.
So in the motions for new trial that have gone forward, I take it still that, they're it's just the tip of the iceberg. It's not like most motions for new trial are going forward. In these cases. You said that some are going forward. Yes, some may be going forward.
I would agree with that. It's,
a handful by
because the
comparison.
defendants are, we're not the only ones asking for a continuance for discovery. Defendants are as well. So, because I think everyone wants to have.
Discovery from you, right? So.
Well, everyone wants to have the complete picture of what occurred in the lab before. And even if not, the court, even the showing that the defendants made here was not enough even to get a hearing on the motion for new trial. I'm talking about specifically the Milette and the Charles cases. There were some representations that she dry labbed. No one had submitted one of the police reports that had been provided in discovery or any of the grand jury minutes in support of their motions to stay executions of sentences. It was essentially the drug cert, and Annie Dukin was the primary or confirmatory chemist, so I should be allowed out. There was no sort of argument that one would expect in the case that, because she dry labbed, the results in my case were tainted. Again, no, as I point out in my brief, no affidavit from any defendant was filed suggesting that the substance wasn't what the Commonwealth alleged it to be at the time the defendant pled guilty. So, I would suggest that the rules have to be followed, or we get the chaos which I suggest ensued in this case. Even with regards to Mr. Milette, the court was.
Chaos has nothing to do with whether the motions for new trial rules are being complied with. The chaos has to do with what happened at the Hinton Lab.
Well, I would suggest the chaos in the sense that the court is unsure. The court is unsure what to do. We see it in these cases where, Judge Liu at one point had to take Mr. Milette back into custody because of a misunderstanding between Special Magistrate Kratzley and whatever his authority were under the order of assignment or the rule.
Wasn't that because of in deference to Justice Botsford's order that he changed the bail situation?
It wasn't in reference to Justice Botsford's order that in Mr. Milette's case, when the Commonwealth had asked Special Magistrate Kratzley to stay his order pending our filing of the objection as set out in the order of assignment, he had refused to stay that. There's evidence in the record that Judge Liu and Special Magistrate Kratzley had then had a conversation between the two, and that now the orders would be stayed. So I would suggest that shows sort of the chaos that goes on. And, had it not been for that, had that order been in place, Mr. Milette wouldn't have been released So it wouldn't have been put in that position.
I'm a bit perplexed as to what you think the world should look like. Now, it's clear that you think that there should be no stays, so I understand that. Is it your view that there should be no special magistrates, that this should be done only by the judges themselves?
No, the appointment of the special magistrate was under Rule 47 within the authority of the court.
And is it your view that they have the authority to hear motions for new trial and to issue proposed findings of fact and conclusions of law?
Yes, under the rule, and because the order of assignment specified specified that they have that authority, which is what Rule 47 allows. Rule 47 allows the Superior Court to give them whatever procedures under the law they can have. They can make proposed factual findings, I would suggest. The comments to Rule 47 suggest that Rule 47 special magistrates are an administrative body rather than an adjudicatory one. So, and it also suggests that the powers aren't as broad as the federal magistrates either. So, and I was going to reserve further on that case until I get to the third case that's before the court, because I don't think it has to do.
But you don't dispute that they have the ability to hear evidence and to make proposed findings of fact and proposed conclusions of law to be adopted or not adopted by a judge.
They do, but there's sort of an vagueness as to that, because, which again goes back to the fact that the rules aren't being followed, in that we don't know what these hearings are to. Say a special magistrate proposes an order allowing for a motion for new trial. Then, what takes place next? Is there a full-scale de novo hearing in front of the Superior Court justice, or does he simply read the findings of fact?
You mean if there's an objection or not?
Yes, if there's an objection. Does he simply read the findings of fact, review the transcript of the motion for new trial hearing? I believe in one of the stay motions, Judge Liu suggested that he was acting de novo and he would hear the matter de novo. So again, I think it just goes to the fact that the rules aren't being followed and need to be followed in order for the just determination of these proceedings. I would like to take my remaining time. Were this court, I know the court has asked me, were the court to find or adopt such a rule under its 211(3) power, inherent authority power, the court could, I would suggest, make some sort of special rule of criminal procedure, which I think is what's called for here, to perhaps refer the matter to the Rules Committee to flesh out what the procedures that should take place under this rule, to sort of make sure that there are standardized procedures that all these cases are going forward under. It's clear from these cases that sort of the courts are feeling their way through the darkness in these special sessions because of their unprecedented nature. So,
but the magistrates were appointed pursuant to Rule 47, which was not created for these problems. It's been there.
Rule 47 has, yes, but the authority of the special magistrate under the rule is very vague, and again, it doesn't even require that, as I point out in my Superior Court brief, that these special magistrates even be attorneys admitted to the bar. The comments suggest there's an intention that they be, and that there's a preference that they be retired judges.
Well, they are. I mean, they're all retired judges. Let's not look at what, maybe they could appoint some, convenience store operator to be a special magistrate. That's not what's going on.
It not likely wouldn't happen, but there's nothing requiring it not to happen, I guess is my point, Your Honor.
That's not really, we can imagine all sorts of things, but the fact of the matter is you have extraordinarily respected and experienced retired judges who are doing this.
And I'm not disputing that fact, Your Honor. I'm simply suggesting that later on down the road, a defendant, and I'll leave the most of it until I get to my third argument, but were a special magistrate to conduct a plea, a defendant could then later come back and say, because a special magistrate wasn't required to be a lawyer or even a retired judge under the.
Do you really think that the Superior Court Chief Justice is going to appoint a convenience store operator?
I don't, Your Honor, but I'm suggesting that there could be claims later on because of the unprecedented nature and the lack of guidance as to the authority of special magistrates, because there were none before this, we're concerned, at least with regard to the plea procedure, of claims later on from defendants suggesting that the judge didn't have the authority to conduct the plea.
And the defendant is not objecting to this?
It's actually affirmatively consenting.
And he's requesting it?
He is, but I guess my time is up, but I'll leave that for my argument when I stand up in the next case. Thank you.
Good morning, Mr. Chief Justice, and may it please the Court. Matthew Siegel for Mr. Milette. With me at council table today is Emma Anderson of the National ACLU. I believe I just heard the district attorney forthrightly agree that its specific arguments about the supposed reconsideration in this case have been overtaken by events. But I've yet to hear the district attorney acknowledge a more fundamental problem with its arguments in all three of these cases, which is that they would make the defendants like Mr. Milette, bear the burden of chaos caused by misconduct perpetrated against them. What I'd like to do today is add a little bit more clarification on the record, but to hone in on this more fundamental problem, because I think it suggests a certain course of action for this court. What it suggests, echoing Ms. Eisenberg's argument in the previous case, is that this court should not only confirm that the Superior Court judges and special magistrates had the authority to do what they did in this case, but this court should clear that up as quickly as possible, and it should order the release of Mr. Milette as quickly as possible. And Mr. Milette is another case study, like the case study that Justice Gantz proposed in the previous case, of just how badly the current litigation is working against defendants. It has been months since he filed for post-conviction relief. His efforts to obtain that relief have yielded additional months in minimum security, then a brief 2-week stay in home confinement, where he was forbidden even to leave the house for routine medical appointments, and then a return to custody in maximum punishment, maximum security.
Can I ask you, your client was convicted of what specifically?
He was convicted, Your Honor, of 4 drug charges.
Selling, distributing?
Trafficking are the first 3 in an amount that yielded a minimum sentence of 5 years. The 4th charge was possession of a Class B substance.
It's not that your client is guiltless in all of this. Your client actually pled guilty because he believed he was trafficking in drugs, and that's what he purported to do, and that's what he was caught doing.
Well, Your Honor, I think the reason that most people plead guilty is based on a judgment about the strength of the evidence against them. And here, the evidence against Mr. Milette on the element of this being drugs was drug certifications by Ms. Dukan, at least in the 3 case charges that yielded imprisonment. And I think,
but if he thought that the nature of the substance and the weight of the substance was really that far off, and according to the information in the certificates, he could have had it retested, couldn't he?
it's possible that he could have had it retested, Your Honor, but I believe that defendants, just like everyone else in the criminal justice system, tend to believe until recently that drug certifications are not the product of fraud.
Well, I take it they tend to believe that what they're selling is the real thing.
Well, in this case, Your Honor, Mr. Milette was a middleman, so he didn't have custody of the drugs that are at issue in this case at any time. He would have been relying on the say-so of the person for whom he was a middleman. I know there's some dispute now about Mr. Milette's role, but the assistant district attorney at the November 2012 stay hearing called Mr. Milette a middleman 3 times. So he was in a very similar position to anyone else. He's relying on someone else's representation about the drugs. But I also want to take a step back from this and point out the legal issue here, which is we're not here about whether Mr. Milette would win a new trial. We're here about whether he would be he has a reasonable possibility of earning one.
So what should the standard be with respect to whether he should get a stay in these circumstances?
The standard we would point to, Your Honor, is the standard that Judge Kratzley applied in the case that's appended to the CPCS and MacDowell brief, which is adopted by the First Circuit and recently by the Fourth Circuit in the cases of Ferrara and Fisher. And what those courts have said, if you have two things, impermissible government conduct that is material to the decision to plea, then what you have is a due process violation warranting reversal of a conviction. And that's what we have here. It may well be that it's a tougher question about whether Mr. Milette would be convicted at a new trial, but his present convictions rest on evidence that is thoroughly tainted. And this, I believe, goes back to the Justice Gant's case study from the first question. In some respects, that case study was a bit kind to the Commonwealth. This is not a situation where everything is sort of up in the air and under investigation. It's true that investigations are ongoing for good reason. But the same Commonwealth that is prosecuting Hector Milette and Shubar Charles is also prosecuting Annie Ducan. And it has told grand jurors in that case that it can prove massive misconduct beyond a reasonable doubt. So the Commonwealth has fairly well made up its mind about whether this is a scandal or not. And it has yet to say that in these cases.
What is the second thing?
The second thing was, Your Honor, was materiality. So there's impermissible government conduct, and then there's whether the evidence tainted by that misconduct is likely to have been material to the decision.
Is that standard for a new trial? I really was thinking about the standard for a stay.
Yes. Well, that would be the standard just to prevail on the new trial motion under probably Rule 30A. But for the stay, it's merely the reasonable possibility of a successful motion for a new trial. And to be honest, on that point, we agree with the amicus brief of the district for Bristol County. The district attorney for Bristol County has submitted a brief to this court which says, if this court applies the customary reasonable possibility standard for stays, then just about any defendant whose case passed through the Hinton lab during Annie Ducan's tenure will be able to satisfy that standard.
You don't agree that therefore we should have a presumption, I mean a higher standard, a different standard?
Right. That's where we part ways with the Bristol district attorney. They say that, which is sort of remarkable, that in the context of this chaos and fraud, that we should actually hold defendants to a higher standard than we normally do. And we say, why don't we, at the very least, not make it harder for them? If this court were just to take the normal stay standard, then it's true, and this is why, Justice Botsford, we advanced such a presumption before you in the single justice session. It's true that the Bristol County District Attorney is right, that would mean a stay in virtually any case that passed through the lab.
How many cases are we talking about?
Well, that's a complicated question, Mr. Chief Justice. In terms of Annie Ducan cases, it seems to be in the neighborhood of 34 or more thousand in the system. But in light of evidence that has come forward recently, it is at least not frivolous for any defendant whose case passed through that lab to file for a stay and for a new trial. I mean, and the fact that it's not frivolous has been addressed even by the outgoing district attorney for Middlesex. So to place these cases in context, Your Honor, that means that however tough it is on the Superior Court right now, dealing largely with motions in Ducan cases from people who are in custody.
Isn't it entirely in terms of custody at the moment?
It is, Your Honor. So we've yet to see the full breadth of the 34,000, let alone what's to come. It's a remarkable situation.
Is there any other standard other than, I mean, is there some other element that one would need to meet in order to get a stay? I mean, your client did plead guilty, so we have a record here. We have a judgment.
I think that's a fair question, Your Honor, and and that's why I would point to two things. First, in terms of the harmlessness of the error, it's about the materiality question goes to the decision whether to plead. And that's why it's not particularly relevant that the Commonwealth believes it could prove Mr. Milette's guilt at a new trial. The question is, how tainted was the evidence it used to obtain the convictions in this case that it now has? And that evidence is fairly well tainted. But the other part of my answer, Your Honor, goes back to why I went to the new trial standard in answering one of your previous questions. These are cases in which the defendants are at the point of beyond showing that they're entitled to stays, but based on the present record, and this is why we cited these Texas cases to your honors, they could prevail right now today on new trial motions. Maybe they will, maybe they won't. And unfortunately, they face a difficult choice in that, because if they want to proceed, they can proceed on new trial motions, but they have to do so with incomplete discovery. The district attorney characterizes that as a strategic choice. I don't think it's part of my client's strategy to have to choose between serving out his sentence or getting full discovery. That's not really the kind of strategy that I would wish upon an attorney.
Now, with regard to the stay, there's a second prong, is there not? There's a risk of flight and risk of committing new crimes.
Right. That's true, Your Honor. And that issue is a fairly easy one in this particular case, but I want to step back from it. In this particular case, it's easy because you have the judgment of both Judge Kratzley and Judge Liu that a stay is appropriate, and you have the separate judgment of the Department of Corrections, which classified Mr. Milette to minimum security before all this started to happen. But putting all that aside, another reason why I'm stressing that a new trial could be had on the present record for most of these defendants is that I think that reduces the relative importance of the public safety prong. If someone is at the point where they've already shown a judge, look, not only do I have a reasonable possibility of getting a new trial, I almost certainly am entitled to one, then it's harder to say that it's okay to keep that person in prison because they might be a public safety risk. But again, in this case, that's a fairly easy consideration. No one has seriously contended that Mr. Milette poses a threat to public safety. If there are no further questions, I'd like to just suggest one thing. Ms. Eisenberg, in the previous argument, talked about the possibility of a remand to the single justice for a ruling with dispatch on the defendant's request for release. I would suggest that it would be a first and important step in reducing the chaos and the burden it is putting on defendants to have that remand or that order come out as soon as possible and in advance of any opinions the court might issue in these cases. If there are no further questions, I'd like to thank the court for its time.
Thank you.
Thank you.